I just realized today is March 9th, the fucking banking holiday. Anyway, bondholders list, section 312A. Each obligor upon the indentured securities shall furnish or cause to be furnished to the institutional trustee thereunder at stated intervals of not more than 6 months and at such other times as such trustees may request in writing all information in the possession or control of such obligor or of any of its paying agents as to the names and addresses of the indentured securities holders and requiring such trustees to preserve in as current a form as is reasonably practicable all such information so furnished to it or received by it in the capacity of paying agent. B. Within 5 business days after the receipt by the institutional trustee of a written application by any 3 or more indentured security holders stating that the applicants desire to communicate with other indentured security holders with respect to their rights under such indenture or under the indentured securities, and accompanied by a copy of the form of proxy or other communication which such applicant or applicants propose to transmit, and by reasonable proof that each such applicant has owned an indentured security for a period of at least 6 months preceding the date of such applicant, such institutional trustee shall, at its election, either one, afford to such applicants access to all information so furnished to or received by such trustee, or two, inform such applicants as to the approximate number of indentured security holders according to the most recent information so furnished to or received by such trustee, and as to the approximate cost of mailing to such indentured security holders the form of proxy or other communication, if any, specified in such application. If such trustee shall elect not to afford to such applicants access to such information, such trustee shall, upon the written request of such applicants, mail to all such indentured security holders copies of the form of proxy or other communications which is specified in such request, with reasonable promptness after a tender to such trustee of the material to be mailed and of payment or provisions for the payment of the reasonable expenses of such mailing, unless within 5 days after such tender such trustee shall mail to such applicants and file with the commission, together with a copy of the materials to be mailed, a written statement to the effect that in the opinion of such trustee such mailing would be contrary to the best interest of the indentured security holders or would be in violation of the applicable law. Such written statement shall specify the basis of such opinion after opportunity for hearing upon the objection specified in the written statement so filed. The commission may, and in demand by such trustee or by such applicant, shall enter an order either sustaining one or more of such objections or refusing to sustain any of them. If the commission shall enter an order refusing to sustain any of such objections, or if after the entry of an order sustaining one or more of such objections, the commission shall find, after notice and opportunity for hearing, that all objections so sustained have been met, and shall enter an order so declaring. Such trustees shall mail copies of such materials to all such indentured security holders with reasonable promptness after the entry of such order and the renewal of such tender. C. The disclosure of any such information as to the names and addresses of the indentured security holders in accordance with the provisions of this section, regardless of the source from which such information was derived, shall not be deemed to be a violation of any existing law or of any law hereafter enacted which does not specifically refer to this section, nor shall such trustee be held accountable by reason of mailing any material pursuant to a request made under subsection B of this section. Reports by indentured trustees. Section 313A, the indentured trustee shall transmit to the indentured security holders, as hereinafter provided, at stated intervals of not more than 12 months, a brief report with respect to any of the following events which may have occurred within the previous 12 months, but if no such event has occurred within such period, no report need be transmitted. 1. Any change to its eligibility and its qualifications under sections 310. 2. The creation of any material change to a relationship specified in paragraph 1 through 10 of section 310B. 3. The character and amount of any advance made by it as indentured trustee which remain unpaid on the date of such report and for the reimbursement of which it claims or may claim a lien or a charge prior to that of the indentured securities on the trust estate or on property or funds held or collected by it as such trustee. If such advances so remain unpaid, aggregate more than one half of 1% of the principal amount of the indentured securities outstanding on such date. 4. Any change to the amount, interest rate, and maturity date of all other indebtedness owing to it in its individual capacity on the date of such report by the obligor upon the indentured securities, with a brief description of any property held as collateral security therefor, except an indebtedness based upon a creditor relationship arising in any manner described in paragraphs 2, 3, 4, or 6 of subsection 311. 5. Any change to the property and funds physically in its possession as indentured trustee on the date of such report. 6. Any release or releases and substitution of property subject to the lien of the indenture and the consideration therefor, if any, which it has not previously reported. 7. Any additional issue of indentured securities which it has not previously reported. And 8. Any actions taken by it in the performance of its duties under the indenture which it has not previously reported and which in its opinion materially affects the indentured securities or the trust estate, except actions in respect of the default notice of which has been or is to be withheld by it in accordance with an indenture provision authorized by subsection B of section 315. B. The indentured trustee shall transmit to the indentured security holders, as hereinafter provided within the time hereinafter specified, a brief report with respect to 1. The release or release and substitution of property subject to the lien of the indenture and the consideration therefor, if any, unless the fair value of such property as set forth in the certificate or opinion required by paragraph 1 of the subsection D of section 314 is less than 10% of the principal amount of the indentured security outstanding at the time of such release, or such release and substitution, such report to be so transmitted within 90 days after such time, and 2. The character and amount of any advance made by it as such since the date of the last report transmitted pursuant to the provisions of subsection A, or if no such report has yet been so transmitted since the date of execution of the indenture, for the reimbursement of which it claims or may claim a lien or charge prior to that of the indentured securities on the trust estate or on property or funds held or collateral or collected by it as such trustee, and which it has not previously reported pursuant to this paragraph, if such advance remaining unpaid at any time aggregate more than 10% of the principal amount of indentured securities outstanding at such time. Such report to be so transmitted within 90 days after such time. C. Reports pursuant to this section shall be transmitted by mail. 1. To all registered holders of indentured securities, as the names and addresses of such holders appear upon the registration books of the obligor upon the indentured securities. 2. To such holders of indentured securities as have within the 2 years preceding such transmission filed their names and addresses with the indentured trustee for that purpose. And three, except in the cases of reports pursuant to subsection B of this section, to all holders of indentured securities whose name and address have been furnished to or received by the indentured trustee pursuant to sections 312. D. A copy of each such report shall, at the time of such transmission to indentured security holders, be filed with each stock exchange upon which the indentured securities are listed and also with the Commission. Reports by obligor, evidence of compliance with indentured provisions, periodic reports, Section 314A. Each person who, as set forth in the registration statement or application, is or is to be an obligor upon the indentured securities covered thereby, shall 1. File with the indentured trustee copies of an annual reports and of the information documents and other reports, or copies of such portions of any of the foregoing as the Commission may by rules and regulations prescribe, which such obligor is required to file with the Commission pursuant to sections 13 of sections 15B of the Securities Exchange Act of 1934. Or, if the obligor is not required to file information documents or reports pursuant to either of such section, then to file with the indentured trustee and the Commission in accordance with rules and regulations prescribed by the Commission, such of the supplementary and periodic information documents and reports which may be required pursuant to Section 13 of the Securities Exchange Act of 1934 in respect of the securities listed and registered on the National Securities Exchange as may be prescribed in such rules and regulations. 2. File with the indentured trustee and the Commission in accordance with rules and regulations prescribed by the Commission such additional information, documents, and reports with respect to compliance by such obligor with the conditions and covenants provided for in the indenture as may be required by such rules and regulations, including in the case of annual reports, if required by such rules and regulations, certificates, or opinions of independent public accountants conforming to the requirements of subsection E of this section as to compliance with conditions or covenants, compliance with which is subject to verification by accountants. But no such certificate or opinion shall be required as to any matter specified in clauses A, B, or C, or paragraph 3 of subsection C. 3. Transmit to the holders of the indenture securities upon which such person is an obligor, in the manner and to the extent provided in subsection C of section 313, such summaries of any information, documents, and reports required to be filed by such obligor pursuant to the provisions of paragraph 1 or 2 of this subsection as may be required by rules and regulations prescribed by the Commission. And 4. Furnish to the indentured trustee not less often than annually a brief certificate from the principal executive officer, principal financial officer, or principal accounting officer as to his or the indenture. For purposes of this paragraph, such compliance shall be determined without regard to any period of grace or requirement of notice provided under the indenture. The rules and regulations prescribed under this subsection shall be such as are necessary or appropriate in the public interest or for the protection of the investors, having due regard to of indentures and the nature of the business of the class of obligors affected thereby, and the amount of indentured securities outstanding under such indentures, and in the case of any such rules and regulations prescribed after the indentures to which they apply have been qualified under this title. The additional expenses, if any, of complying with such rules and regulations may be prescribed either before or after qualifications become effective as to any such indenture. Evidence of recording of indenture. B. If the indenture to be qualified is or is to be secured by the mortgage or pledge of property, the obligor upon the indenture securities shall furnish to the indenture trustee, 1. Promptly after the execution and delivery of the indenture, an option, an opinion of counsel, who may be of counsel for such obligor, either stating that in the opinion of such counsel, the indenture has been properly recorded and filed so as to make effective the lien intended to be created thereby, and reciting the details of such action, or stating that in the opinion of such counsel no such action is necessary to make such lien effective, and 2. At least annually after the execution and delivery of the indenture, and upon an opinion of counsel, who may be of counsel for such obligor, either stating that in the opinion of such counsel, such action has been taken with respect to the recording, filing, re-recording, and refiling of the indenture as is necessary to maintain the lien of such indenture, and reciting the details of such action, or stating that in the opinion of such counsel no such action is necessary to maintain such lien. Evidence of compliance with conditions precedent. C. The obligor upon the indentured securities shall furnish to the indentured trustee evidence of compliance with the conditions precedent, if any provided for the indenture, including any covenants compliance with which constitutes a condition precedent, which relates to the authentication and delivery of the indentured securities, to the release and substitution of property subject to the lien of the indenture, to the satisfaction and discharge of the indenture, or to any other action to be taken by the indenture trustee at the request or upon the application of such obligor. Such evidence shall consist of the following: 1. Certificate or opinions made by officers of such obligor who are specified in the indenture, stating that such conditions precedent have been complied with. 2. An opinion of counsel who may be of counsel for such obligor, stating that in his opinion such conditions precedent have been complied with. And 3. In the case of conditions precedent compliance with which is subject to verification by accountants, such as conditions with respect to the preservation of specified ratios, the amount of net quick assets, negative pledge clauses, and other similar specific conditions, a certificate or opinion of an accountant who, in the case of any such condition precedent to the authentication and delivery of the indentured securities, and not otherwise, shall be an independent public accountant selected or approved by the indentured trustee in the exercise of reasonable care, if the aggregate principal amount of such indentured securities and of other indentured securities authenticated and delivered since the commencement of the then current calendar year, other than those with respect to which a certificate or opinion of an account is not required, or with respect to which a certificate or opinion of an independent public accountant has previously been furnished, is 10% or more of the aggregate amount of the indentured securities at the time outstanding, but no certificate or opinion need be made by any person other than an officer or employee of such obligor who is specified in the indenture, as to a. Dates or periods not covered by annual reports required to be filed by the obligor in the case of conditions precedent, which depend upon a state of facts as of a date or dates, or for a period or periods different from the required to be covered by such annual reports, or b. the amount and value of property additions, except as provided in paragraph 3 of subsection D, or c. the adequacy of depreciation, maintenance, or repairs. Certificates of fair value. D. If the indenture to be qualified is or is to be secured by the mortgage or pledge of property or securities, the obligor upon the indentured securities shall furnish to the indentured trustee a certificate or opinion of an engineer, appraiser, or other expert as to the fair value, 1. of any property or securities to be released from the lien of the indenture, which certificate or opinion shall state that in the opinion of the other person making the same, the proposed release will not impair the security under such indenture in contravention of the provision thereof, and requiring further that such certificate or opinion shall be made by an independent engineer, appraiser, or other expert, if the fair value of such property or securities and of all other property or securities released since the commencement of the then current calendar year, as set forth in the certificates or opinions required by this paragraph, is 10% or more of the aggregate principal amount of the indentured securities at the time outstanding, but such a certificate or opinion of an independent engineer, appraiser, or other expert shall not be required in the case of any release of property or securities if the fair value thereof, as set forth in the certificate or opinion required by this paragraph, is less than 25,000 or less than 1% of the aggregate principal amount of the indentured securities at the time outstanding. 2. To such obligor of any securities other than indentured securities and securities secured by a lien prior to the lien of the indenture upon property subject to the lien of the indenture, the deposit of which with the trustee is to be made the basis for the authentication and delivery of indebtedness securities, the withdrawal of cash constituting a part of the trust estate, or the release of property or security subject to the lien of the indenture, and requiring further that if the fair value to such obligor of such securities and of all other such securities made the basis of any such authentication and delivery, drawal, or release since the commencement of then current calendar year, as set forth in the certificate or certificates or opinions required by this paragraph, is 10% or more of the aggregate principal amount of the indentured securities at the time outstanding. Such certificate or opinion shall be made by the independent engineer, appraiser, or other expert, and in the case of the authentication and delivery of indentured securities shall cover the fair value to such obligor of all such securities so deposited since the commencement of the current calendar year, as to which a certificate or opinion of an independent engineer, appraiser, or other expert has not previously been furnished, but such a certificate of an independent engineer, appraiser, or other expert shall not be required with respect to any security so deposited if the fair value thereof to such obligor, as set forth in the certificate or opinion required by this paragraph, is less than 25,000 or less than 1% of the aggregate principal amount of the indentured securities at the time outstanding. And 3. To such obligor of any property the subjection of which to the lien of the indenture is to be made the basis for the authentication and delivery of indentured securities, the withdrawal of cash constituting a part of the trust estate, or the release of property or security subject to lien of the indenture, and requiring further that if A, within 6 months prior to the date of acquisition thereof by such obligor, such property has been used or operated by a person or persons other than such obligor in a business similar to that in which it has been or is to be used or operated by such obligor, and B, the fair value to such obligor of such property as set forth in such certificate or opinion is not less than 25,000 and not less than 1% of the aggregate principal amount of the indentured securities at the time outstanding. Such certificate or opinion shall be made by an independent engineer, appraiser, or other expert, and in the case of the authentication and delivery of indentured securities shall cover the fair value of the to the obligor of any property so used or operated which has been so subjected to the lien of the indenture since the commencement of the then current calendar year, and as to which a certificate or opinion of an independent engineer, appraiser, or other expert has not previously been furnished. The indenture to to be qualified shall automatically be deemed unless it is expressly provided therein that such provision is excluded, to provide that any such certificate or opinion may be made by an officer or employee of the obligor upon the indentured securities who is duly authorized to make such certificate or opinion by the obligor from time to time, except in cases in which this subsection requires that such certificate or opinion be made by an independent person. In such cases, such certificate or opinion shall be made by an independent engineer, appraiser, or other expert selected or approved by the indentured trustee in the exercise of reasonable care. Oh. Recitals as to basis, recitals as to basis of certificate of or opinion. E. Each certificate or opinion with respect to compliance with a condition or covenant provided for in the indenture other than certificates provided pursuant to subsection A4 of this section shall include: 1. A statement that the person making such certificate or opinion has read such covenant or condition. 2. A brief statement as to the nature and scope of the examination or investigation upon which the statements or opinions contained in such certificate or opinion are based. 3. A statement that, in the opinion of such person, he has made such examination or investigation as is necessary to enable him to express an informed opinion as to whether or not such covenant or condition has been complied with. And 4. A statement as to whether or not, in the opinion of such person, such condition or covenant has been complied with. Parties may provide for additional evidence. F. Nothing in this section shall be construed either as requiring the inclusion in the indenture to be qualified of provisions that the obligor upon the indentured security shall furnish to the indentured trustee any other evidence of compliance with conditions and covenants provided for in the indenture than the evidence specified in this section as preventing the inclusion of such provision in such indenture if the parties so agree. Duties and responsibilities of the trustee. Duties prior to default. Section 315. A. The indenture to be qualified shall automatically be deemed unless it is expressly provided therein that any such provision is excluded, to provide that prior to default, as such term is defined in such indenture. 1. The indenture trustee shall not be liable except for the performance of such duties as are specifically set out in such indenture. And 2. The indenture trustee may conclusively rely as to the truth of the statements and the correctness of the opinions expressed therein, in the absence of bad faith on the part of such trustee, upon certificates or opinions conforming to the requirements of the indenture. But the indenture trustee shall examine the evidence furnished to it pursuant to sections 314 to determine whether or not such evidence conforms to the requirements of the indenture. Notice of default. B. The indenture trustee shall give to the indentured security holders, in the manner and to the extent provided in subsection C of section 313, notice of all defaults known to the trustee within 90 days after the occurrence thereof, provided that such indenture shall automatically be deemed, unless it is expressly provided therein that such provision is excluded, to provide that, except in the case of default in the payment of the principal of or interest on any indentured security, or in the payment of any sinking or purchase fund installment, the trustee shall be protected in withholding such notice if and so long as the board of directors, the executive committee, or a trust committee, or directors and or responsible officers of the trustee in good faith determine that the withholding of such notice is in the interest of the indentured security holders. Duty of the trustee in case of default. C. The indentured trustee shall exercise in the case of default, as such term is defined in such indenture, such of the rights and powers vested in it by such indenture and to use the same degree of care and skill in their exercise as a prudent man would exercise or use under the circumstances in the conduct of his own affairs. Respon- Responsibility of the trustee. D. The indenture. The indenture to be qualified shall not contain any provisions relieving the indenture trustee from liability for its own negligent actions, its own negligent failure to act, or its own willful misconduct, except that 1. Such indenture shall automatically be deemed, unless it is expressly provided therein that any such provision is excluded, to contain the provisions authorized by paragraph 1 and 2 of subsection A of this section. 2. Such indenture shall automatically be deemed, unless it is expressly provided therein that any such provision is excluded, to contain provisions protecting the indenture trustee from liability for any error or of judgment made in good faith by a reasonable officer or officers of such trustee, unless it shall be provided that such trustee was negligent in ascertaining the pertinent facts. And 3. Such indenture shall automatically be deemed, unless it is expressly provided therein that any such provision is excluded, to contain provisions protecting the indenture trustee with respect to any actions taken or omitted to be taken by it in good faith in accordance with the directions of the holders of not less than a majority in principal amount of the indentured securities at the time outstanding, determined as provided in subsection A of sections 316, relating to the time, method, and place of conducting any proceedings for any remedy available to such trustee, or exercising any trust or power conferred upon such trustee under such indenture. When we come back, we'll be talking about undertaking for costs.